there's descriptive material, then he's entitled to confront the speaker.
There's not descriptive material of the defendant, Your Honor. This is not a confrontation issue.
You've heard it before?
Yeah, I've seen it in its editorialization.
He's already made statements, assertions of fact.
He just made one.
He did.
Okay, we can play it without the audio. There will be times in which we will have audio of interactions with the defendant where he makes statements.
Defendant's statements are admissible.
All right, I'll do my best to alert you when those occur. So let's play without sound for now.
When I studied evidence last century, the evidence textbook, which was probably about this thick, about a quarter of it was dealt with the hearsay rule. You hear the word hearsay all the time, and the section on the hearsay rule began, there is nothing murkier in the law of evidence than the hearsay rule. And I can tell you from 50 years of experience that that is accurate. It is a rule that has many, many exclusions, and it has many, many exceptions. So some things that may seem to the untrained ear to be hearsay are not, and some things that don't seem like it are. Basically, the rule is that a statement of a non-testifying person cannot be offered to prove the truth of the matter which is asserted in the statement. The rule, this is something we actually referred to on the first day when I talked about what's introduced in evidence has to be under oath. It has to be subject to cross-examination. And that's not true of statements that are made by somebody who's not here while testifying as a witness. He's not here on the stand, he's not under oath, and he's not subject to cross-examination. So this person who's describing this is carrying on a discussion that you or I might have if it didn't require the strict rules that we have in the courts, perfectly, ordinary conversation. But when it gets into court, and this is actually referred to in the Bible, St. Paul, when he was put on trial, in this is, I think it's Caesarea. Well, it was over in Palestine, in Israel. He was accused of some activity, and he was a Roman citizen, which was not common, but he happened to have been a Roman citizen, and so he had rights that we share now as Americans. And when they tried to put him on trial with evidence which was being repeated by somebody who wasn't there and under oath, he said, "Where are the witnesses against me? I am a Roman, and I have a right to confront my accusers. They should be here." And so that led to actually his voyage to Rome to have his case heard before the emperor. So it's an ancient rule. It's strictly enforced in the criminal courts for very obvious reasons. So that's what we're talking about here. And so if the person who's making this descriptive material is here and can be put under oath and cross-examined, then it's admissible. But otherwise, it is not admissible through the officer here. You can play the video. And now, one of the exclusions from the operation of the rule, there was reference here to there were apparently statements, the state claims were made by the accused. there's an exclusion. That is not hearsay. A statement made by a party opponent is not hearsay. So he's entitled, the district attorney is entitled to have the sound up during those if they are statements of the defendant himself. So, go ahead.
I will continue the video without sound. There will be a moment in which, shortly, where we'll turn the sound back on, but for now we'll just play without sound.